human rights in general, I will try to focus on specific areas like farmers' suicide or death, honor killing, poverty or a drought situation in the state, rights of children living in a jail with their mothers, corruption as a violation of human rights of the people, and fake encounters or extrajudicial killings by police personnel. These areas are very familiar to you, so I don't discuss something new, but my perception, my approach is discussing the issue from judicial perception. How the judiciary has looked into the issue and directed the state or central or state governments to implement the guidelines issued by the court the concerned. You know, a country's prosperity or development is measured by how it respects and protects and fulfill the human rights of the people. If you look at the prosperous country, if you look at the economic developed countries, you find respect and protection, or you find respect to the human rights of the people of the particular countries concerned. India is a signatory to almost all the international treaties and conventions of human rights and the treaties. In a democratic country like India, one of the primary objectives is the protection of rights of the people. Democracy and protection of human rights go hand in hand. No democracy without protection of human rights. No human rights exist without the democracy. You look at the Middle East countries where you do not find their respect to the human rights of the people because there's no democracy at all. Contrarily, you look at European countries where the human rights of the people are respected. And European country which has contributed a lot for the promotion of the human rights in the world. You think of yourself, you know, a European Convention on Human Rights, UGC-HRDC, and UDHR, or International Covenant on Civil and Political Rights, International Covenant on Socio-Economic and Cultural Rights. These are the products of the initiation taken by the European and Western countries. If you look at the Constitution of India, you do find the reflection of human rights, values and the culture. You look into part 3 that contains the civil and political rights in terms of fundamental rights. Part 4, which covers economic, social, and cultural rights in terms of directive principles of state policy. And if you look at the preamble to the Constitution of India, you do find the fundamental human rights of the people: justice, equality, liberty, fraternity, and dignity of the individual. These are the 4 pillars of the Constitution of India. It is the duty of both the central and state government to ensure that these fundamental rights are enjoyed by the people without any discrimination by any reasons. The Constitution imposes duties on the government to work for the welfare of the people and protection of the human rights of the people. Mere declaration of rights does not serve the objective of protecting dignity of the individual. What is important is free enjoyment of rights by the appropriate mechanism. Therefore, Article 32 guarantees right to constitutional remedies, right to approach the fundamental right to approach the Supreme Court for the enforcement of a fundamental right itself is a fundamental right provided by Article 32. It is the constitutional duties of the judiciary to protect human rights of the citizens. Supreme Court and High Courts are empowered to take action to enforce the rights. Article 32 and 226. An aggrieved person can directly move the Supreme Court or the High Court, as the case may be, for the protection of or enjoyment of the fundamental rights. In such cases, courts are empowered to issue appropriate orders, directions, writs in the nature of a habeas corpus, mandamus, prohibition, quo warranto, and certiorari. If you are aggrieved that your fundamental right is violated by the state, your fundamental rights is blatantly violated by the state, the central or the state governments, it is your right to move the Supreme Court under Article 32 or the High Court under Article 226 for the enforcement of your rights. Under these circumstances, it is the bounden duty of the Supreme Court or the High Court to issue appropriate order or the direction in the nature or writs in the nature of habeas corpus, mandamus, prohibition, quo warranto, and certiorari. Judiciary in particular, the Supreme Court under Article 32 or the High Court under Article 226, as the case may be, is ultimate sentinel of the fundamental rights or the human rights of the people. Judiciary not only enumerates rights, but also expands the horizons of the fundamental rights by the way of the interpretation. In Motilal was a state of Uttar Pradesh, which was decided in 1951, 1 year after the independence. The Supreme Court observed that fundamental rights are natural rights or human rights. So in 1951, the question that before the Supreme Court was as to examine the nature of the fundamental rights, whether it is whether the fundamental rights are the natural rights or the human rights. The court observed that fundamental rights are natural rights or the human rights. In 1954, then Chief Justice of India, Patanjali Sastri, held that fundamental rights are those basic rights which are recognized and guaranteed as natural rights in a free democratic country. So according to Chief Justice, ex-Chief Justice Patanjali Sastri, the fundamental rights are those, the basic rights which are recognized and guaranteed as natural rights in a free democratic country. In 1961, then Chief Justice of India, Justice Subbarao, has rightly observed that fundamental rights are modern name for what has been traditionally known as natural rights. Fundamental rights are the modern name for what has been traditionally known as natural rights. If you see Article 21, you will be ponder what is not included in its scope. Right to life includes right to privacy, right to travel abroad, right to live with human dignity, right to livelihood, right to shelter, right to health and medical assistance, right to education, right to free legal aid, right to fair trial, right to food, right to compensation, and so on. You have to think what has been left out from the scope of Article 21. The judiciary has included within the scope of the Article 21 almost all human rights of the people. Perhaps nothing is left out from the purview of Article 21 of the Constitution of the India. With this backdrop, I would like to discuss the role of a judiciary, in particular the Supreme Court, in the protection of human rights, with a special reference to farmer suicide, honor killing, distress or drought situation, rights of children living in jail with the mothers, corruption as a violation of human rights, and fake encounters by the police. The first issue about which I try to draw your attention is farmer suicide, farmers harm, farmers death. Just 2 years ago, the Union of a Ministry conducted a survey across 13 states, 13 states, to find out reasons, that drive farmers to commit suicide. Survey reveals the cause for death or suicide by farmers as frequent crop loss, vagaries of a monsoon, absence of water resources, attacks of pests and diseases, deaths or alone, farming and social causes. NCRB, National Crime Records Bureau, which disseminates and compiles information on suicide in farming or agriculture, reveals the causes of suicide among farmers: loan, farm-related issues, family problems, illness, drug abuse, or alcoholism. Every year, around 4,000 farmers commit suicide. Every year, around 4,000 farmers commit suicide. In 2017, more than 10,000 farmers committed suicide. Judiciary initially was not interested to take up the issue of farmers' suicide or the death, because there was no direct involvement of the state. The direct involvement of the state or its the instrumentalities. Therefore, the judiciary did not take into the account the farmer's death or the suicide. However, in 2017, NGO moved the Supreme Court, directing the central government to take measures to prevent death of farmers. The Supreme Court asked the center to provide an action plan to end the tragedy. The central government in its affidavit responded that it has implemented policies for the better welfare of the farmers. The central government argued that it has initiated or it has fixed minimum support price, provided credit facilities, crop insurance, and disaster compensation, and other policies. Here, states are not consulted, credits are taken are cornered by non-farmers. Some policies are against the farmers' interest. Failure on the part of the government to control farmers' death is a clear case of violation of human rights of farmers. The Supreme Court observed that the government's welfare scheme should not remain on paper. The compensation was no solution to deal with the problems of a farmer suicide, as the key reason for this suicide was inability to pay back their debts. The court directed the center to formulate policies or measures to deal with the issue of a farmer suicide, and directed the central government to revise the minimum support price for food grains. So in 2017, for the first time, the Supreme Court of India, they considered farmer suicide in the country as a serious issue. The center should deal with the real issues which compel them to take an extreme step. The court said, now the time has come to move from the paper to the implementation of pro-farmer the policies. So here, the Supreme Court has considered that farmer suicide for any reason whatsoever violates the human rights of the farmers. Therefore, it is the responsibility of the central and state government to take measures to deal with the issue of farmer suicides. The second issue about which I would like to discuss, there is drought situation, distress situation. You have seen here, poverty is a violation of human rights. Girl children being sold by their own mothers because there are other children to feed. In the winter season, poor people die, freezing on the pavements. People have a basic rights, fundamental rights and human rights. But to me, these rights are meaningless to a population suffering from utter deprivation and the poverty. What is the use of a freedom of speech if you do not have a food, if you do not have a meals to eat, shelter to live, cloth to wear, access to medical facilities, or basic the education? Therefore, the Supreme Court has rightly observed that right to life includes right to food, shelter, work, medical facilities, good environment. Failure on the part of the government to respect these rights amount to violation of the human rights of the other people. In Swaraj Abhiyan's case, in Swaraj Abhiyan versus Union of India, 2017, NGO filed a writ petition under Article 32 before the Supreme Court to declare certain areas as drought areas. States of Bihar, Gujarat, Haryana refused to acknowledge a drought-like situation or a drought or a distress by not disclosing a full facts about prevailing conditions in these states. A drought is not required to be declared in the entire state or in the entire district. If a drought-like situation or a drought exists in some of the village or in a district or some taluk or block, it can be declared by the state government. The state government gets financial support from the Union of India. The court in this case, they held that failure of these states to declare drought effectively deprives rights of the poor to live with dignity guaranteed under Article 21 of the Constitution of India. So in this case, the court observed that failure on the part of the state government to declare a taluk or a particular the block of the area as the drought, it violates the human rights of the people. There is no loss of a face or a prestige or a dignity of the state government if it is warranted. It will help the farmers prevent migration of a people from the affected areas, suicides. It improves the plight of a women and the children. The court observed that National Food Security Act is not being implemented, even though it is a social justice and beneficial the legislation. So in this case, the court observed that, see, if you do not declare the area has a drought area, then it violates the human rights of the people living in the particular area. And it amounts to failure on the part of the government to implement the provisions that contained in National Food Security Act. The court directed the authorities concerned to conduct meetings and discuss about means and ways to implement the provisions of National Food Security Act. The court directed to constitute, establish, and make fully functional state food authority under the provisions of the National Food Security Act. A fully functioning vigilance committee has to be established by the state government so that the committee can fulfill the duties and responsibilities enshrined in the Act. Social audit committee should be established by the Secretary, Ministry of Consumer Affairs, so that the state government can make social audit whenever it requires to check the machinery. So in this case, Swaraj Abhiyan, the case, the court observed that failure on the part of the state government to implement National Food Security Act, the court directed the Secretary of the department concerned to hold the meetings to discuss about the means and ways to implement the provisions of the Act. The court also directed the government to constitute State Food Committee, State Food Commission to implement the provisions of the Food Security Act, and also directed the government to constitute the Vigilance Committee and Social Audit the Committee. The court has taken the role of a monitoring authority and monitored the various schemes undertaken by the union and state governments such as NREGA and Food Security Act. The implementation of the NREGA scheme was tremendously improved after the Supreme Court monitoring the scheme. So here we can argue that the Supreme Court monitoring the welfare scheme amounts to usurpation of the role of the executive or encroaching upon the jurisdiction exclusively reserved to the executive and the legislatures. But nobody complied. The reason is that corruption, indifference, apathy of the government towards the right of the people and violation of the human rights. Extreme poverty is denial of human rights of the are the people. This is the landmark, the ruling of the Supreme Court, in which the Supreme Court itself monitor the implementation of Narega scheme and other the welfare scheme, and safeguarded the human rights of the people, the concerned. Now, I will discuss honor killing. You often come across with the incident of honor killing. No state is exception to this, including the Karnataka. What is honor killing? It's a murder of a person accused of bringing the shame or humiliation to his or the family. It is committed by people who want to defend the reputation of their family or community. Is it an honor to kill a girl who marries a boy from the lower caste? In the last 3 years, more than 300 people died in the name of honor killing. The important case of honor killing is Manoj Babli honor killing case. A boy and a girl who belonged to the same Gotra married and defended their relationship. Therefore, both were killed by the order of a Kap Panchayat, just because a boy and a girl married, or a boy and a girl who belong to the same Gotra, they married, they were killed by the order of a Kap Panchayat. In 2018, the Supreme Court rendered a ruling in Shakti Wahini versus Union of India. Shakti Wahini versus Union of India, in which the court observed that any attempt by Kap Panchayat to prevent two consenting adults from marrying is absolutely illegal and laid down preventive, remedial, and punitive measures in this regard. The court held that any criminal case pertaining to honor killing or violence to the couple shall be tried before the designated court or fast track court earmarked for that purpose. The trial must proceed on a day-to-day basis, to be concluded preferably within 6 months from the date of taking cognizance of the offense. This direction shall apply to all pending cases. The concerned district judge shall assign those cases to the jurisdictional court so as to ensure speedy disposal of the case. The judgment also says that Kap Panchayat should not take law into their own hands and cannot assume the character of a law implementing agency that has not been conferred upon them under any law. It was the duty of the government to protect life and dignity of those harassed by the assemblies or the communities. No individual or group has right to interfere with consented legal relationship between two adults. There is no honor in so-called honor killing. India's constitution provides not only right to life, but also right to dignified life. The right to choose one's life partner is an integral right to life. If a marriage is legal, No individual or group of individuals has any right to interfere. The state government should identify the areas where honor killing have been reported and direct the police to be extra cautious in dealing with the cases. The officer not below the rank of a deputy superintendent of a police should investigate the case. The police shall provide protection to couples facing threats if they so desire their marriage and facilitate their marriage and registration. The court directed the central government to constitute or to consult states to draft a law against honor killing and follow these guidelines until such a law is enacted. So in Shakti Vahinisi case, the court laid down the guidelines for the protection of the rights of the couple, the who belongs to the different religion or different the caste. So the court directed the government to try the cases of honor killing by a designated court, complete the trial within 6 months from the date of the taking cognizance of the case, and assign this case to the jurisdictional court so as to assure the speedy disposal of the case, and cop panchayat not to take the law into their own hands and assume the character of the law implementing agency. So here the court observed that the right of the couple who belongs to the different caste of the religion should be protected by the governments, and it is the responsibility of the police to facilitate the marriage and the registration of the marriage. So this is the leading case wherein the court considered honor killing as violation of human rights of the first couples who belong to the different religion or the caste. Now another issue about which I would like to draw your attention is children living in a jail with the prisoner mother. You might have seen the children who are living in the jail with the mothers. Children are denied of their child rights guaranteed by the statutes and the international conventions. If a child is born in the jail, the authorities concerned will record the place of birth as a jail in the birth certificate. So in view of this, in R.D. Upadhyaya versus State of Andhra Pradesh, 2006, a writ petition was filed by the NGO highlighting the plight of children living in jail with their mothers, requesting the court to pass appropriate directions for their proper care, welfare, and the development. It was argued that despite of several constitutional provisions and the laws made thereunder, such as Article 15, Article 15 Clause 3, Article 14, Article 21A, Article 23, Article 39E, Article 42, 45, 46 to 47, laws such as Guardians and Wards Act, Child Restraint Marriage Act, Hindu Marriage and Maintenance Act, Juvenile Justice Act, Probation of Offenders Act, National Policies of the State, and Commitment of the Government of India to United Nations Convention on Rights of Children. The plight of children, particularly living in jails with their mothers, has not been improved. The Supreme Court, showing a serious concern regarding plight of children living in jail, issued detailed directions for providing food, shelter, medical care, clothing, education, recreation facilities, which are declared to be child's right. The court held that before sending to jail a woman who is pregnant, the authorities must ensure minimum facilities, providing the prenatal and postnatal care for both the mother and the child. Birth of a child in prison, not to be recorded as a prison in birth certificate. It shall be registered in a local birth office. Child above 6 years are not to be kept with a female prisoner. The court directed the jail manual must be amended suitably so as to incorporate the changes. So in this case, the court has taken into the consideration the serious violation of the human rights of children who are living in the jail with the prisoner of the measures. We have provisions in the Constitution. We have n number of statutes enacted by the Parliament and the state legislatures. We have formulated a number of policies for the welfare of the children, yet the children who are living in jail are deprived of the basic rights guaranteed by the United Nations Convention on the Child. Therefore, the court directed the governments concerned to take the measures for protecting the human rights of the children. Another issue which is relevant to the present scenario, corruption. Where corruption violates the human rights of the people. Please, you remember, corruption threatens the rule of law, democracy, and human rights, undermines good governance, fairness, and social justice, distorts competition, hinders economic development, endangers the stability of a democratic institution and the moral foundation of the society. The term corruption derives from the Latin word corruption, which means moral decay or wicked behavior or rottenness. Corruption violates human rights. When the state or official prevents individuals from enjoying the human rights by corrupt means. Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights provides that corruption-free governance is a basic human right. Corruption is really human rights violation, in particular, right to life, liberty, equality, non-discrimination, fair trial, access to justice, right to political participation, etc. As per 2010 Corruption Index, India ranks 87th out of 178 countries. India ranks 87 out of 178 the countries. India has ratified United Nations Convention against the corruption. In CBI, Union of India versus Balakrishna Kumbar, which was decided by the Supreme Court in 2012, the court observed that corruption is a violation of human rights. Corruption is a violation of the human rights. Further, the court observed that corruption is not only punishable offense, but also undermines human rights. A systematic corruption is a human rights violation in itself, as it leads to systematic economic crimes. So in CBI, Union of India versus Balakrishna Kumbar, the court examined the impact of corruption upon the human rights of the people, and it observed that corruption violates human rights of the other people. The last issue about which I would like to draw your attention is extrajudicial killings or fake encounters. Recently, in Uttar Pradesh, Vinay Dubey, a gangster, was gunned down by police a day after his arrest. It created a debate around extrajudicial killing by the police personnel. The Supreme Court has laid down the guidelines for dealing with the cases of encounter killings. In the People's Union for Civil Liberty versus Union of India 1997, Prakash Kadam versus Ram Prasad Gupta 2011, and People's Union for Civil Liberties versus State of Maharashtra 2014, the Supreme Court has laid down the guidelines for the preventing the cases of encounter or extra killing by the police. Whenever the police receives any intelligence or tips about the criminal movements or the activities pertaining to the commission of the grave criminal offense, it shall be reduced into writing, preferably in a case diary. So the first direction, the first guidelines, the laid down by the Supreme Court, there is that whenever the police receives any intelligence, any tips about the movements or the activities of the criminals, about the commission of crimes, it shall be reduced into the writing. In particular, in a case diary, if an encounter takes place or firearm is used by the police, as a result, death occurs, FIR shall be registered and the same shall be forwarded to the court. So if the encounter takes place or firearms is used by the police, as a result, death occurs, the FIR shall be, first information report shall be registered and the same shall be forwarded to the magistrate. An independent investigation shall be conducted into the incident by CID or the police team of another police station under the supervision of senior police officer. So whenever encounter takes place, there shall be independent investigation by the CID or the police team of another police station under the supervision of a senior police officer. And it is the function of the team to identify the victim and taking the photographs of the victim, recover and preserve the evidentiary materials, including blood-stained cloth, hair, fibers, threads, etc., relating to their death. Identify scene witnesses with complete names, addresses, telephone numbers, and obtain their statements concerning the death. So when the encounter takes place, it shall be investigated by the police officer of the another police station, and it is the duty of the investigation agency to identify the victim, recover the evidentiary material, other things, identify the witnesses, determine the cause, the manner, location, and the time of death, send the fingerprints of the deceased for chemical analysis, and post-mortem must be conducted by 2 doctors in the district hospital. One of them should be head of the district, the hospital, recover and preserve any evidence of a weapon, such as the guns, bullets, cartridge. Cause of death should be found, whether it was a natural death, accidental death, or suicide or homicide. A magisterial inquiry must be held in accordance with the CRPC. The information of the incident without any delay must be sent to the NHRC or SHRC, as the case may be. It should be ensured that there is no delay in sending FIR, diary entries, panchanamas, the sketch, etc. to the other court. After full investigation into the incident, the report should be sent to the competent court under CRPC, the provisions. The next kin of the alleged criminal or the victim must be informed at the earliest. If the police officer is found responsible for the death, disciplinary action must be initiated against such officer promptly, and he be placed under suspension. No promotion, reward should be given to him. So in this case, the Supreme Court observed that when the police receives any intelligence about criminal activities, it should be recorded into writing and take up the investigation by the police team of another police station, and the court identified the powers and the responsibility of the investigation, the team, and how the disciplinary action can be taken against the police officer involving in the encounters or the case. So here you find that how the Supreme Court has made an attempt to protect the human rights of the victim of fake encounters or extrajudicial or the killings. So with this, I conclude the discussion on the role of a judiciary and the protection of human rights. And it is open for interaction.
Good morning, sir.
Yes.
I am Dr. Sunil Bagde from Karnataka State Law University.
Okay.
Sir, the way the judiciary has delivered the judgment in matters relating to upholding of the human rights is really welcoming. But
okay,
when it comes to enforcement, what
okay,
we find is that judiciary lacks the system of enforcing the judgments itself. Sometimes its judgments remain in black and white rather than being enforced strictly.
yes.
So in the say for instance, after striking down of section 66A of Information Technology Act,
Okay.
several arrests were done, though that particular provision was not a constitutionally valid provision.
Yeah.
So in this regard, what you suggest, sir? Do you whether we should have some system wherein judiciary should constantly monitor the enforcement of its judgments?
No, here, see, the Constitution, the entire Constitution is based upon the fundamental principle like separation of powers.
Okay, sir.
The legislature is to make a legislation. The executive is to implement the law enacted by the legislatures.
Okay.
And the judiciary is to adjudicate the disputes
Okay.
and interpret the law in case of any ambiguity. It is for the parliament to make the appropriate legislation. The task or the primary, the function of the judiciary is to adjudicate disputes according to law. In case of any ambiguity, or if the language of the statute is not clear, then the judiciary will interpret the language or the provisions concerned. See, in Abhiman's, in one case, Swaraj Abhiyan's case, the judiciary taking into account impact of a drought situation upon the human rights of the people. See, if the particular area is declared as a drought or a distress, the government concerned will get financial help support from the government of India. It would implement the various schemes for the welfare or better welfare of the people concerned. In this case, the court not only laid down the guidelines, but monitored the implementation of the welfare schemes initiated by the government. You look at this case, the court not only looked into the situation, drought situation, but ventured into implement the welfare schemes of the government. Here, strictly the enforcement of any scheme, it is for the government, not for the judiciary. But in the instant case, the court monitored the implementation of various schemes. Implementation of a scheme, implementation of a law effectively is left to the government, not for the judiciary. If the government implements or monitor the implementation of any law, then it amounts to encroaching the power which is reserved for the legislature. Therefore, it is not for the judiciary to implement the law enacted by the parliament. We have a law, as you said, we have n number of laws, the plenty of laws, excellent laws we have. Perhaps the only the India where we have n number of legislations, but we fail in the implementation. The reason is the apathy on the part of the executive authorities. There is no wrong with the judiciary. Okay. The judiciary cannot take the task of the implementing the legislation or the welfare. It is wrong.
Okay. Thank you, sir. Thank you, sir.
Sir, good morning, sir.
Good morning.
This is Dr. Nagasheshamma, sir.
Okay, madam, tell me.
Sir, one small doubt for me. Okay. Is this what you told about this encountering, sir?
Yeah.
Extrajudicial killings. Yes. Whatever it may be. So what I am telling you, see the example of the 2 years back about the gang rape which happened in Hyderabad and Nirbhaya case.
Yes,
Nirbhaya case it took so.
Yes.
Yeah. Police people they have encountered the people, but it's a pakka plan only. They want to kill. It is not morning. They don't. Early morning 5 o'clock. So they told that we are taking towards the court, and that is why they are revolt against. We are killed. That is the thing which they told. Yeah. So in case if it is happened in those circumstances, National Human Rights Commission they came because it is a violation of human rights. We had to see what it did like that. Yes. If you come to the Nirbhaya case, so it is happened long back and it is dragged like anything. And so recently they have given the decision for them and they have given the decision punishment for them. Is it in, sir? Yes. And in these both cases, which one is correct, sir?
Madam, you are a law teacher, you know.
Yes, sir.
Yeah, you decide it.
No, sir.
You decide
So what?
which one is
So-
correct, whether Nirbhaya's case or Hyderabad killing. No,
The
as a
judicial
student of a
system-
law, no, as a student of a law,
Yes, tell me, sir.
Hyderabad encounter killing is wrong. We can agree with the Nirbhaya's case, wherein the accused were given fair trial and access to justice and complied with the rule of law. Whereas in Hyderabad, false encounter killings, the accused were killed mercilessly by the police force itself. And you, as the teacher of law, you know that police doesn't have the power to kill
Yes,
any
yes.
individual, any person. May be accused with a serious crime, but the police has no power to kill. If that is the case, perhaps there is the need of a judicial system and the rule of law.
Sir, what I'll tell you, what is one thing, if 100 innocent, 100 criminals escape, no problem, one innocent should not be killed, punished,
Yeah,
that is correct.
Yes.
That is the
Yeah.
law correct only. But
Yeah.
if you see practically what I'm telling, see in Nirbhaya case, they are filing the cases, filing so much. Simply they are filing to drag the case only. Is it, sir? That is true or not? And moreover,
No, we cannot say that.
No, sir, this is the right only. I'm telling, if we go to the law, sir, it is if we think law, that is the true that they are having a right to file a case before the court of law, whatever their problem. That is,
yes.
Yeah, that is true. What you are telling is, if you see practically, sir. So how many people they are escaping like that? Some of the cases are what you can say that here till see after the Nirbhaya case and so many judgments which is given by the Supreme Court, High Court with regard to rape cases, still it is happening. The crime is happening. So the people don't have any fear. It will take time. No problem. In that situation, so what I'm telling, so this Hyderabad case is correct, but not like law. I'm telling practically.
No. As a student of law, we cannot agree with.
Sir, we cannot agree. That is true, sir.
Criminals by the police force, we cannot agree.
Police people should not, sir. They should not take their, into their judiciary is there, independent judiciary is there. But the thing is that this is the situation which is happening in India. So many people are suffering, sir. So many people are suffering. Some of the cases not coming out also. In those circumstances, is it not a violation of human rights for those people, sir?
So you support for extrajudicial killing?
No, I am not supporting for that, sir. There is a confusion in my mind, sir. Whether kitchen is correct, this one is correct, or that one is correct. If they practically see, this is correct. If the law see, that is Nirbhaya case is there. It is so much of confusion in my mind, sir. So much of fighting is going on in my mind. For that, I want clarification, sir.
In PUCL, People's Union for Civil Liberty and State of Maharashtra, 2014, a landmark ruling on extrajudicial killing. The court has taken into consideration the ground reality. Court has, they taken the cognizance of the reality, and there was no law which regulate the extrajudicial killing. And we have various authorities. We have NHRC or SHRC, and you have various, the mechanisms. Despite of these, we do come across with the extrajudicial killing. We cannot, they give the much power to the police to eliminate the lives of the criminal, unless otherwise it is in accordance with the rule of law. Hello.
Hey, lock कर ले बराबर अंदर बैठ रहा.
Hello.
Hello, sir.
Yes, please.
Hello, sir.
Yes,
Sir.
Go ahead.
Sir, good morning, sir.
Good morning.
Sir, I am Manjunath from Judiciary College. Sir, my question is, nowadays, number of mob lynching incidents are raised in India, sir. What is the role of Apex Court of India?
No, the court has taken into the consideration the incidents of a mob lynching. Court has looked into this issue, and it's clear violation of human rights. Mob lynching is not permitted. It's a bad. It's against the human rights of the people that concerned. See, in mob lynching, what happens is the mob of the group takes the law into their own hands. So it is bad in the law. Mob lynching is a clear case of violation of human rights. Hello?
Hello, sir. Hello, sir.
Yes,
Thank you,
please.
sir.
You got the answer, Manjunath?
Sir,
No, you got the
Hello?
answer. Yeah, you got the
yes,
answer.
sir.
You support for mob. You support for mob lynching.
No, sir. No, sir.
Yeah, is it not a violation of human rights?
Yes, sir. 100%, sir.
Yes, it's violation of human rights. We cannot agree. The people, it is
Sir, whether
nothing but. See, it is nothing but the state of anarchy.
yes, sir. Yes, sir. Sir, whether central government is able to take any action against the persons involved in mob lynching, sir?
No, it is for the state government to take action, not for the central government.
Yes, sir. Because of
government
policy
concerned.
state subject.
State government has to take action or formulate any policy for preventing mob lynching.
Okay, sir. Thank you, sir. Thank you very much.
Sir, good morning, sir.
Hello?
Hello.
Yeah.
Sir, Dr. Chandrasekhar, Principal of Siddhartha Law College, Gulbarga, sir.
Hello?
Hello.
Yeah.
Sir, Chandrasekhar Untitled. Sir, regarding this children living with child mothers. Hello. Hello.
Yeah.
Hello. Sir,
Yes,
children living with child mothers.
Yeah. Okay.
Any guidelines is given back to in this case, sir, R.T. Upadhyaya versus State of AP?
Yeah. No, I didn't follow your question.